In this lesson, I'm going to go over the California divorce process in 3 simple steps. Make sure you review the divorce checklist before starting this lesson to get a broad understanding as to the forms you're going to need to complete to file for divorce and obtain that divorce judgment. So the first step in filing for a divorce is making sure you meet California residency requirements. So California law requires a spouse to have resided in California for at least 6 months before filing for a divorce. In addition, either spouse must have resided in the county in which the divorce has been filed for at least 3 months before submitting the petition. If you are unsure as to whether you have satisfied the residency requirements, definitely reach out to me at info@sdesquire.com and I can help you figure that out. In addition, you're going to need to verify which superior court you're going to be filing your documents with. There's going to be a subsequent lesson to show you how to do that. So don't be overwhelmed with the text on the screen, but this slide just highlights the forms the petitioner is going to have to complete in order to file for a divorce. Now keep in mind that Form FL-105 and Form FL-311 may be optional. It should only be attached to FL-100 if the petitioner has minor children, being children under the age of 18. FL-160 does not have to be attached with the initial petition, but the petition would have to be amended, and FL-160 will have to be incorporated into the petition in the event the respondent fails to provide a response within the 30-day statutory period with the court. So the respondent's going to complete the forms listed on this screen in order to start the divorce process on his or her behalf. Again, the respondent has 30 days of being served with the divorce papers to file a response, and the response is going to consist of FL-120, FL-105, FL-311. Again, if there are minor children's forms listed under 2 and 3 must be filed with the court, and then any applicable forms must be filed as well. So the next step in the divorce process is to complete financial disclosures. Both parties have 60 days to provide the other party with financial disclosures. The 60-day clock starts for the petitioner when he or she files the petition for dissolution with the court. So from that filing day, they have 60 days to provide the respondent with their preliminary disclosures. Once the respondent files his or her response with the court, he or she has 60 days to provide and serve their financial disclosures on the petitioner. Here's a list of financial disclosures that must be exchanged in a default divorce. You'll see that FL-160 again because that is the request the petitioner is going to make to the judge regarding the evaluation of property and debt and how it should be divided between the parties. The following financial disclosures listed on this page must be served on the respondent when completing an uncontested divorce. So a key difference between default and uncontested is that default, again, FL-160 versus an uncontested FL-142 is used the schedule of assets and debts. In addition, when the respondent files a response with the court, both parties can later waive financial disclosures. Now, the final step in the California divorce process, once financial disclosures are completed, is to prepare the final judgment documents. The final judgment documents can take up to 2 weeks to complete, depending on whether you're filing for a default divorce judgment or seeking to obtain an uncontested divorce judgment. So these are just some of the forms that a party may need to complete for a default divorce judgment. I say some because depending on whether or not you have extensive assets or debts, or if you're looking for spousal support or child custody, you might not need to complete those forms. So the basic forms, FL-190, FL-165, FL-170, FL-180, must be filed with the court. Optional forms are the child support FL-342. So if you are requesting child support, then you're also going to have to file FL-191 with the court to register your child support order attachment. If you're looking for spousal or family support, you're going to have to complete FL-343. If you're looking to divide any marital property, including assets and debts. You're going to be looking at FL 345 and the child custody and visitation, if that is also an issue or not an issue, if that also needs to be addressed as far as how child custody and visitation schedule is going to occur, you'll need to complete FL 341. So when we get to those lessons, I provide details as to whether or not you need to complete certain forms and instructions on how to complete those forms. If you are in an uncontested divorce, as you can see, there are a lot less forms the parties will have to complete. Some of the same base core forms, but they just won't be completing all the attachments that were referenced on the previous slide, as most likely all that will be captured in the marital settlement agreement, which will be signed by both parties and notarized. Please keep in mind there was a lot of information provided in this lesson as references to forms. I just wanted to break it down into 3 different phases. That way you know how to categorize the forms you need to fill out based on which phase you are in the divorce process. Thank you, and please proceed to the next lesson after you finish reviewing the text on this webpage.